Yes, Mr. Flynn.
My Lords, I'm Vernon Flynn and I appear on behalf of the Appellant, the Russian Federation, with
Yes.
Mark Wassouf, Cameron Miles and Maud Mullen, instructed by Pinner Goldberg. Jonathan Crowe, CVO KC, appears on behalf of the respondent with David Peters KC and Naomi Hart, instructed by Stevenson Harwood. I've had a discussion with my learned friend and he's asked for 3 hours and I've said I'm happy for him, subject to your lordships, to have 3 hours. That was half of the original estimate.
Right.
I know we're listed for slightly longer, but...
Sorry, could you speak up a bit?
Of course, absolutely. I take it your lordships have done the pre-reading.
Yes.
I'm grateful. As your lordships will have seen, this appeal raises an important question as to the scope of the English court's obligation when it's faced with an assertion of adjudicative immunity by a state under Section 1 of the State Immunity Act 1978. There are 5 grounds of appeal. Grounds 1 to 3 really boil down to a simple question. In very short summary, it's this: can a court in England and Wales base its decision as to the existence of state immunity on an issue estoppel arising from a decision of a foreign court? That is in essence what this appeal is about. Now
that's the key question.
That's the key question, my Lord, yes. And that question can be unpacked a little more in the following way, breaking it down. Can an English court, bound to extend adjudicative immunity to a state under Section 1 of the SIA, unless an exception to that adjudicative immunity is proved by the claimant under any one or more of Sections 2 to 11 of the SIA, rely on the existence of an issue estoppel, produced in this case by a foreign court, to satisfy itself that the relevant exception has been met? And we submit the answer to that question. All of those questions must be no. And we say that essentially, you'll see from our skeleton, on the basis of 3 points. They're independent, but they're mutually reinforcing routes to the same answer. And they're in summary as follows. First, that the obligation of the English court to give effect to immunity under Section 1 of the SIA may only be satisfied by an autonomous determination, applying the civil standard of the factual and legal arguments said to give rise to immunity. A conclusion based on an issue estoppel arising from a foreign judgment is not a determination at all, certainly not one to the civil standard. The second point is that reliance on issue estoppel for the purposes of determining immunity would be to use estoppel to expand the court's jurisdiction, and binding authority from this court makes that impermissible in the case of the State Immunity Act. And thirdly, the adjudicative immunity of a state and the English court's obligation to satisfy itself as to the scope of that immunity reflects an important rule of public policy in England, more important than issue estoppel and the underlying policy in favour of finality. And if and when the two are engaged, as they are in this case, the court's forced to engage in a balancing exercise as to which should be given priority. In this case, that balancing exercise leads to only one outcome. Immunity takes priority and cannot be less removed or lessened.
Not quite sure I entirely follow the last of the points. How does the court, assume there are 2 competing public policies, both of which are of some importance, how does the court choose between them?
Because then I'll come to that, and I just, at the beginning of my submissions on the substance, I wanted to explain what is different about immunity. How is it different to a normal issue, if I could put it that way, like issue estoppel, like the policy behind finality? And one of the reasons is there is an obligation on the state itself, the UK in this instance, to give effect to state immunity. And if I can put that, that's on a different level of public policy to general issues of litigation interests, such as finality. So that if one is looking at the 2, they're on a very different level. And so that's why we say immunity takes priority over finality. And I'll come to that because I did want to just say a few words about what is different about state immunity. Why is it treated differently? What is underlying that? And why is it that issue estoppel can't be relied on in relation to immunity? And I need to put that in a bit of context.
Right.
So your lordship may be right. Sometimes it's quite difficult to work out the relative weight of different public policies. The court sometimes has to do that and reach a conclusion. Here in my submission it's very different because of the nature of state immunity. It's a very different concept to finality. So I'm going to try and take it as quickly as possible. And as I say, my lord, if I'm labouring anything you've read it, please just do say, but I'll take it in order. That's the broad route map, and I want to start with the scope of the court's obligation under Section 1 of the SIA. And it is worth just looking at the statutory provision. That's in volume D for those who have hard copies at tab 49, page 1802. And what you see there is section 1.1 provides that a foreign state is immune from the jurisdiction of the court, both its adjudicative and enforcement jurisdictions, unless an exception in part 1 of the SIA is established. Now, just pausing there, of course, adjudicative immunity is the immunity that a state enjoys from the court's jurisdiction to determine a dispute at all. And the exceptions to that immunity within the SIA are set out in sections 2 to 11. Whereas enforcement immunity is the immunity of state assets from enforcement for the purposes of satisfying judgments and arbitration awards. And the exception to that immunity is set out in section 13 of the SIA at page 1808. You don't need to turn that up now, but it's just important to have that distinction in mind. So for an arbitral award to be enforced in the UK, both immunities must be satisfied. The English court must ascertain that it has adjudicative jurisdiction over the claimant's claim for recognition and enforcement of the award, and that the state is not immune from this claim. And if the court is so satisfied, it must then ascertain that the particular asset against which enforcement sought is also not immune. Now, in this appeal, we're concerned only with the adjudicative immunity. And it's only if the court is satisfied that the Russian Federation is not immune from the adjudicative jurisdiction of the English courts that questions of enforcement and enforcement immunity arise. And section 1.2 imposes an obligation on the court to give effect to the immunity conferred by this section, even though the state does not appear in the proceedings in question. That gives you an indication of the importance of this principle. So section 1 contains a positive obligation on this court to hold the foreign state immune from the court's adjudicative jurisdiction, unless it, that is the court, is satisfied that the state is not immune because one of the exceptions in the SIA applies. And even if the foreign state is not present, the court is required to make the claimant prove that adjudicative immunity does not apply. And whilst we're here, it is worth looking at section 9, which is the section in issue here, which is the exception for arbitration, section 9.1. That provides where a state has agreed in writing to submit a dispute which has arisen or might arise to arbitration, the state is not immune as respect proceedings in the courts of the United Kingdom which relate to the arbitration. Now, that is not the usual situation on jurisdiction, either generally or with respect to arbitration claims. I.e. the state immunity question, which is the court has an obligation to consider itself. And the question is why? Why is the state's immunity given such extraordinary treatment? And the simple answer is that state immunity is given extraordinary treatment because states themselves are extraordinary, at least insofar as litigation in the English courts is concerned. In this sense, state immunity has a dual character. It's fair to say that this court and all other English courts apply it on the basis of the State Immunity Act. But the State Immunity Act merely reflects the parallel regime of state immunity under international law. And indeed, within international law, state immunity has been described by the International Court of Justice as deriving from one of the fundamental principles of the international legal order. You'll find that in the bundle. I won't ask you to turn it up, but it's in volume D, tab 47, 1765. I'll take you later to the decision where that's been held. But the principle is that this is the idea that states are sovereign and therefore equal. And one equal cannot sit in judgment on another. And that's captured by the Latin maxim, par in parem non habet imperium, which is summarised by Lord Sumption in the Ben Carbuche case. And again, that's in the authorities bundle. In the interest of time, I won't take it to you, but I'll tell you what Lord Sumption said at paragraph 17. The reference is volume A, tab 7, page 161. State immunity is a mandatory rule of customary international law, which defines the limits of a domestic court's jurisdiction. Unlike diplomatic immunity, which the modern law treats as serving an essentially functional purpose, state immunity does not derive from the need to protect the integrity of a foreign state's governmental functions or the proper conduct of interstate relations. It derives from the sovereign equality of states, par in parem non habet imperium. And it's for this reason that Lord Mustill said in Holland and Lamp and Wolf, and again, It's a short paragraph, so I'll read it to you, but it's in Volume B, tab 17, page 626. Lord Mustill said, "State immunity is a creature of customary international law and derives from the equality of sovereign states. It is not a self-imposed restriction on the jurisdiction of its courts, which the United Kingdom has chosen to adopt." And just pausing there, very important distinction to the sort of issues like finality. This is imposed from outside. As Lord Mustill says, he goes on to say, it is a limitation imposed from without upon the sovereignty of the United Kingdom itself. And you can see from those citations that that puts state immunity on a different level, if I can put it this way, ordinary issues of public policy and so on, or limitations on the court's jurisdiction. This is a limitation on the jurisdiction imposed from outside. It is worth turning up the Privy Council decision in Fang, which is relatively recent. That's in Volume C, tab 35. Starts at page 1329. But the paragraph I want to show you is at paragraph 170 at 1377. Tab 35, page 1377.
Sorry, which paragraph?
Paragraph 170.
Yeah.
Should be marked in your...
Yes.
And that is the finding of Lords Hamlin, Stevens and Lady Rose. And they all see the obligation on the courts to respect the immunity of sovereign states was described by Lord Justice Aikins in NML Capital in Argentina. He said that Section 1 of the SIA imposes a duty on all UK courts in imperative terms to give effect to the immunity conferred. An English court is bound to refuse to entertain any proceedings against a state unless it is satisfied that the state is not immune because it falls within one of the exceptions set out in Sections 2 to 11 of the Act. Now, I'll come back to some of those statements in the course of my submissions, but I mention them here to establish the non-discretionary character of state immunity, a character which derives from state immunity's origin outside English law as a matter of international law. And that's important because state immunity, conceived of as a matter of international law, is not about the relationship between the parties to the litigation, in this case the respondents and the Russian Federation. It is about the relationship between states, and in this case the relationship between the UK and the Russian Federation. And the point is also important because in the context of that relationship, the English court is not just a court, if I can put it that way. It is an organ of the UK, and its actions are attributable to the UK. And where an English court takes adjudicative jurisdiction over a foreign state in defiance of state immunity, that will give rise to a claim by the foreign state against the UK in international law. So it has far-reaching consequences. And that is exactly what, that's not a theoretical risk, that is exactly what occurred in the case we put before you called the jurisdictional immunities case for the ICJ. It's very often referred to in this jurisdiction, and we rely on it in several respects. That is worth turning up. It's Volume D, tab 47, page 1738. And while you're turning it up, I'll just tell you a little bit about the case. Germany instituted proceedings against the Italian Republic, requesting that the court declare that Italy failed to respect the jurisdictional immunity which Germany enjoyed under international law. And it advanced the decision on the basis that Italy had allowed certain civil claims to be brought against it in the Italian courts for reparations arising from the Second World War without properly giving effect to Germany's immunity. If you could go first to paragraph 56 at 1765. Again, that's marked in the point I wanted to emphasise is the last sentence of 56. That practice shows that whether in claiming immunity for themselves or according it to others, states generally proceed on the basis there is a right to immunity under international law, together with a corresponding obligation on the part of other states to respect and give effect to that immunity. And then if you go on to 57, the court considers that the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which, as Article 2, Paragraph 1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. This principle has to be viewed together with the principle that each state possesses, then over the page, sovereignty over its own territory, and that there flows from that sovereignty the jurisdiction of the state over events and persons within that territory. Exceptions to the immunity of the state represent a departure from the principle of sovereign equality. Immunity may represent a departure from the principle of territorial sovereignty and the jurisdiction which flows from it. It is also worth, while we're here, just looking at paragraph 82, page 1778, it's another passage marked. At the outset, however, the court must observe that the proposition that the availability of immunity will be to some extent dependent on the gravity of the unlawful act presents a logical problem. Immunity from jurisdiction is an immunity not merely from being subjected to an adverse judgment, but from being subjected to the trial process. It is therefore necessarily preliminary in nature. Consequently, a national court is required to determine whether or not the foreign state is entitled to immunity as of a matter of international law before it can hear the merits of the case brought before it, before the facts have been established. If immunity were to depend upon the state actually having committed a serious violation of international human rights law or the law of armed conflict, then it would become necessary for the national court to hold an inquiry into the merits in order to determine whether it had jurisdiction. On the other hand, the mere allegation that the state had committed such wrongdoings would be sufficient to deprive the state of its entitlement to immunity. Immunity could in effect be negated by a skillful construction of the claim. And then you can, if you look on at 139, what happened in the case was you'll see that the court did indeed declare.
Paragraph 139.
139, yes. It's just the conclusion of the court.
Yeah.
Because the court there in that case did determine that there had been a breach. And I'll just read it to you. The Italian Republic has violated its obligation to respect the immunity which the Federal Republic of Germany enjoys under international law by allowing civil claims to be brought against it based on violations of international humanitarian law committed by the German Reich between 1943 and 1945. So I hope that, in a sense, answers to some extent the question about why one policy would be more important than another. Because this is a rare case where if the court gets it wrong, it puts the UK in breach of it, potentially puts the UK in breach of its obligations. So given what I've just said and shown you, there's nothing to suggest that an English court can in effect permit itself to be satisfied that the important obligation imposed by Section 1 has been discharged by relying on the determination of a foreign court. Those show you that this principle is extremely important, and each state has an obligation to apply the principles of state immunity unless it is satisfied that, that one of the exceptions applies. And as I say, that's because it's potentially, to get it wrong is potentially to place the UK's international responsibility towards another sovereign in the hands of a third state. And apart from one case, there is nothing before the court, nor before Mrs. Justice Cockerill, to suggest that other states allow issue estoppel or any other delegation to another state on issues relating to state immunity. And the respondents rely on that one case, that's the Indian Deutsche Telekom case from Singapore, for the opposite proposition, namely that an issue estoppel arising from a foreign judgment may be used to dismiss a claim to state immunity in respect of a claim to enforce an arbitral award. And I'll come to that. It's in volume D at tab 56. I won't say very much at this stage because that case was hidden in the respondent's skeleton. You may not have noticed it, but it was a footnote in their skeleton. So they didn't loom large on it. But just I should probably say now what we say about it. That case doesn't assist their argument because in that case there was no principled objection by India to the court's reliance on issue estoppel in arriving at a determination of state immunity. So the point was never considered nor decided. So far as our submission is that India and Deutsche Telekom isn't a proper authority for any propositions.
India claimed state immunity.
Yes, state immunity arose, yes. And then...
And the court decided it by reference to what they call transnational estoppel.
Exactly. I see your lordship's had a look at that case. Yes, absolutely. And that terminology is yes, transnational issues.
So your point is that it wasn't argued for India that transnational estoppel was simply not an available tool.
In relation to state immunity, yes. And yes, so as you also, I'll keep it very brief. Deutsche Telekom obtained a Swiss arbitration award against India. India had applied to the Swiss courts to try and have the award set aside. The Swiss courts dismissed India's application. Deutsche Telekom then tried to have the award enforced in Singapore, and then India resisted enforcement in Singapore on the basis that it had state immunity under Section 3.1 of the Singaporean State Immunity Act, which is materially identical to Section 1.1 of the UK State Immunity Act. Similar exception there, that where the state has submitted to arbitration, which is in Section 11 of the Singapore Act, again, are materially identical to Section 9 of the State Immunity Act 1978. India asserted that the tribunal did not have jurisdiction, and therefore the exception in Section 11 of the Act didn't apply. But some of the arguments about the validity of the award raised by India in the Singaporean courts were the same as those it had previously raised in the set-aside application in Switzerland, as you would appreciate. And that had been rejected by the Swiss courts. And the threshold question in that case was whether an issue estoppel operated to prevent India from raising those arguments again in Singapore. So obviously some similarities, but the crucial point is India didn't assert in principle that a transnational issue estoppel could not operate when the Singaporean courts were determining the question of state immunity. So they didn't consider that issue.
It's odd, though, that the point would have escaped such a strong court.
Yeah, potentially, yes. But they didn't have any of the arguments that your lordships have. And the question is, why are they wrong? So that's correct, Homer nods, you're right, but it wasn't put before them. And courts are sometimes very cautious about dealing with matters when they're not raised before them. What the position in that case was that no issue estoppel operated because there was no doctrine of issue estoppel under Swiss law. They took a different point. They said, well, you can't, the Swiss don't have issue estoppel. I mean, that's one of the issues, sort of a broader issue, which is civil states don't necessarily have the doctrine of issue estoppel. So why would it be, it's a bit odd that only the common law courts would be applying this doctrine when determining state immunity, if that is the position. But that was the point taken by India. They didn't take the point that we're taking before your lordships. And they say because the Swiss court the Swiss law doesn't have a doctrine of issue estoppel, the Swiss judgment didn't create a res judicata. So, as I say, the Singaporean Court of Appeal didn't consider and didn't have an opportunity to consider in our submission. The key issue in this appeal is an issue estoppel arising from a decision of a foreign court capable of serving as a basis for a determination as to whether a statutory exception to a judicative immunity arises. So, your lordship's right. They did find a transnational issue estoppel operated against the state on the case before it, but there is no support there in our submission on the points that are before your lordships on this appeal. It simply wasn't an issue considered by them. The better view, we submit, is that the English court must determine for itself, essentially de novo, whether an applicable exception to the state's judicial immunity arises under Section 1. And as I noted, that applicable exception in this case is Section 9 concerning arbitration codes. Now the consequence of that is an obvious one, that the issues, what's said against me, that the building blocks are all there, they've all been decided against you. And I can't say that. That's correct, as one would expect. But the consequence is, if this court determines it for itself, there will be duplication. And there's no doubt about that. The issues of Section 9 will have to be determined by the English court on ordinary principles, on a balance of probabilities. So there will inevitably be duplication, but that is no answer to our point of principle in the submission. Similar situations arise under Section 67 in the context of an arbitral substantive jurisdiction, an arbitral tribunal. They don't have the final say, the court has the final say, the court duplicates what the arbitral tribunal heard, hears the same evidence again, reaches its own conclusion de novo. It's not an unheard of situation. And we suggest that state immunity is even more important than the substantive jurisdiction of an arbitral tribunal, important though that is. And that's because of the engagement of the state itself and the treaty obligations of the UK and the potential ramifications. So, just to be clear, the Russian Federation is not saying that a foreign state can never be subject to an enforcement action in respect of an arbitration award. We're not saying that a foreign state will always be immune. What we are saying is there are no shortcuts to the court's determination of immunity by way of issue estoppel. That is not permissible. The court must undertake the task for itself and not in effect allow the determination of the courts of third-party states to dictate this court's own determination of immunity. So this court must determine for itself normal principles, balance of probability, so make an actual determination. And whilst that submission does give rise to inconvenience in a certain extent for a claimant, that the need to prove that Section 9 is satisfied under the State Immunity Act is plainly outweighed by the need for the English court to ensure that it has not wrongfully taken jurisdiction over the foreign state. So that, in a nutshell, is why this court must determine for itself and cannot have regard to the determination of another state. However,
determining the issue for itself doesn't avoid the possibility, does it, that the English court may get it wrong, or in a way that
yes,
international law would regard as wrong,
yes,
and therefore the UK would still be in breach of its international obligations on the international plane.
Absolutely, my lord, it could be. And of course, the court could be wrong. I mean, that actually dovetails with our fifth ground, right down the chain. But what the court is considering on these issues are issues of international law, where no domestic court has a final say. It's rather different to the ordinary course, where a judge can say, this is English law, there may be some issues about this, but I'm confident I can resolve those, I can give a proper answer, and I can determine the question, and I'm confident I'm right. And then it goes off to appeal. Here, the court can be wrong. No, I accept that. But then it will be subject to the normal process of the first instance judge being subject to the possibility of an appeal and appeal from that. So it has the usual safeguards. One cannot avoid the situation that the English court might be wrong, but it does have to determine it for itself. It can't be wrong. It is wrong in my submission if it were to rely upon an issue estoppel and effectively not determine, because the effect of the issue estoppel is to say it's no longer an issue between the parties because it's been determined, and therefore I don't have to determine it because I'm applying the usual principles of issue estoppel.
But
so,
in determining the question for itself, would the English court, be applying English law or some other law?
It would be applying the principles in Section 9 of Section 1 and Section 9 of the State Immunity Act.
How would it apply those principles? In accordance with English law or some other law?
It would be effectively applying English law under the statute, but it would have regard to the treaty obligations.
So what? It's applying a modified version of English law, is it?
Well, I suppose in one sense it's English law, but it's actually looking to international. The international law has been embodied in the statute, so it doesn't disregard the learning on on international law, but it's strictly applying statutory provisions. I wanted to show you next, if I may, there are echoes of that in Mr. Justice Butcher's judgment in Tatneft, which is in Volume C, tab 26. It wasn't a case involving issue estoppel arising from a foreign court, but the sense of what I've just said comes through in my submission in the judgment. Tab 26, paragraph 35 at page 1034. So just to go back to Lord Justice Mail's question, one can never fully remove the possibility that any court might be wrong, however eminent, however distinguished the judge. But in my submission, our point is a different one, which is it would be wrong for any judge to rely on issue estoppel of a foreign court. That would be wrong in principle. If the court's determining it, the court will be determining it on normal principles, and of course it might be wrong. But that is the process that needs to be done, the ordinary process of determination and the balance of probability.
Well, I asked the question because I thought you were submitting that the English court needs to determine the point for itself in order to avoid the risk of being in breach of its international obligations, but you're not saying that, I think.
No.
What would the position be then if the foreign court decides that there is no valid arbitration clause, so the English court could quite safely give effect to an estoppel then, without running your risk of being in breach of its obligations?
It's just trying to think through how that would work, because if let's say you have a foreign seated arbitration, the tribunal rules it doesn't have jurisdiction, then the party challenging that would be the party bringing the claim, and the party then bringing the claim would go to the court of the seat of that jurisdiction to try and challenge that and say that the tribunal did have jurisdiction. You then have a judgment saying there wasn't jurisdiction. It would be quite hard to see how this court from a foreign seat would be involved in that case, because you wouldn't have an award.
Well, you could have an award because the tribunal holds it does have jurisdiction, which is then challenged, and there is a submission to the jurisdiction of the court of the seat, so that all the requirements for issue estoppel are satisfied. But the court of the seat decides that there is no jurisdiction, and then the claimant seeks to enforce the award here.
But there, you see, but if your lordship's saying in that case there would be, the court would say there's no jurisdiction, there's no award, because the tribunal didn't have substantive jurisdiction, there'd be nothing to bring to the foreign court in that hypothesis. You wouldn't have an award in that case, because there'd be nothing to enforce, because the court has said there is no jurisdiction, there is no award, so you wouldn't be able to enforce it on that basis.
Okay.
Why not?
Because there wouldn't be
if this court has to decide for itself,
yes,
whether the foreign state has agreed to arbitrate, why cannot this court decide, yes, contrary to what the court of the seat held, yes, the state did agree to arbitrate?
If it arose, my lord, the answer is yes, the court would have to determine for itself. But in terms of the question, the situation in which this would arise is the court of the seat of the arbitration has said there's no award, there's no jurisdiction, so there's actually nothing to bring here. The way in which it usually arises is there is an award. Either the tribunal and the courts have said there is an award, there is consent to arbitration, you have an award, you then take it to another state to enforce. It's only once you have it. The hypothesis put to me was, well, what if the court says there isn't? Hard to see how that would come to England, because somebody would be saying, although the courts of the seat says there is an arbitration, I still want to try and enforce it. Very difficult. If it did arise, the answer I think is still the same in principle. If it were to arise, this court still has to decide for itself. Still has to decide that issue. It can't circumvent that. And that's the short answer. I was going to show you, Mr. Justice Butcher, paragraph 35. Do you have that page? 1034. By reason of section 1.1 of the State Immunity Act, it's immune from the jurisdiction of the court, unless an exception provided for in the SIA applies, and indeed the court is obliged to give effect to that immunity, even if the state doesn't appear. So I do say that there are certain situations where the court has an independent obligation, even if the state isn't there. It's an unusual situation where the court has to give effect to immunity, even if the state doesn't appear. What that entails in the present case is that the court would have to give effect to the immunity unless it's satisfied the state has agreed in writing to submit a dispute to arbitration, and the proceedings relate to the arbitration. If there is an issue which is either apparent to the court or its own motion, or is raised by the state, and which goes to the question of whether there was such an agreement in writing in relation to the relevant dispute, then I consider the court is obliged to consider it, and can only exercise jurisdiction over the state if satisfied that the Section 9 exception is nevertheless applicable.
Can I just test this proposition that the court must decide for itself?
Yes.
Because the court's always dependent upon the parties before it raising the evidence and the arguments on which it's going to rely.
Yes.
And we have a number of procedural rules which would debar a party from raising evidence or raising arguments, in which case you may reach the same result if those were applied against the state.
Yes.
But the court would be assuming rather than deciding the point, because the state's unable to advance the point for a procedural reason.
Yes, I mean,
in that circumstance, would the court be complying with Section 1 or not?
The court still, I mean, you're absolutely right. Because of the nature of this obligation, which is that the court, if an issue occurs to the court, then the court has to, if the state isn't present.
No, but the state is present, but fails to comply with procedural rules, in my example.
Oh, well, that's a different issue. We get that in one of the cases, or it touches on that, which is if the state is taking part, does it have to comply with the normal procedural rules? And the answer to that in my submission is yes. There still has to be a determination by the English court of the issue, but if the state breaches the rules, doesn't put in evidence and so on, that is a different situation. I think it's Zhongyang which goes to that, which is the court. It doesn't mean that the court is the state is immune from complying with rules and can come back 5 years later and put in evidence subsequently. They still have to comply with the normal process, but the process is one of determination in the ordinary way. So it's not an escape route, if I can put it that way, from complying with the court's procedure. In this case, all the court is the issue that the court is concerned with is, can the English court have regard to the foreign court's determination to create an issue of estoppel? And the answer to that question, in my submission, is no. Now, once you get beyond that, you then get into issues such as your lordship's raised, which is, it doesn't mean that it's carte blanche to ignore the rules. You have to comply with the normal procedural rules, but that issue has to be determined. And as Mr. Justice Butcher says, if there is an issue which is either apparent to the court of its own motion or is raised by the state, then the court's obliged to consider it and can only exercise jurisdiction if satisfied that the Section 9 exception is nevertheless applicable. Now, one can see that there might be, in some cases, some very difficult issues where the court considers that there is immunity but doesn't have all the evidence and so on. That is something that could arise. It doesn't arise on this appeal. It's something that might arise in another case. But how does the court deal with that? That's for another day. It's not for today. The issue for today is, can the court rely on an issue of estoppel of a foreign court, a decision of a foreign court to create an issue of estoppel? In my submission, the answer to that is plainly no. So what does it mean in practice? There are two key judgments on this. That's the Juan Carlos case and the London Steamship case. Now, I was going to take your lordships to those unless you don't need me to, but those are the two key cases on this issue. And if I can start with Corinna Suzanne, that's in Volume A, at tab 10, page 331. Now, while you're finding that, tab 10, the court will recall that this was an appeal by the former King Juan Carlos of Spain in the context of proceedings brought by a woman with whom he previously allegedly had a relationship. She brought a claim against the former king for alleged harassment and seeking damages, and the former king, asked the court to declare it had no jurisdiction to try the claim on the basis he was entitled to immunity under the SIA. And you'll see that from paragraph 4 of the judgment. That case was heard by Mr. Justice Nicklin at first instance, and he dismissed the application. The former king then obtained permission from this court to appeal Mr. Justice Nicklin's findings in relation to whether the former king had functional immunity under section 14(1) of the State Immunity Act. So very different from the basis before you today. But the relevant point emerges from the verse ground on which the former king appealed at paragraph 8A of the judgment. That's page 336. We see, your lordship will see that the former king's first ground was that in reaching his substantive conclusion, the judge adopted an erroneous approach to the legal test by considering only whether the cause of action, namely harassment, was of a nature that any private citizen could perform, and by failing to conduct a closer analysis of the individual acts alleged, and in particular to consider whether they were done under colour of authority, whatever their motive. And you'll see the parallel. Here was an appeal partly concerned with whether the lower court should have looked at the basis for asserting immunity more closely. And then if you go on to paragraph 13 of the judgment, there's some helpful background on the context of the SIA. It's at page 337. And what it says is, the SIA replaced and codified the domestic law on state immunity. Under the SIA, foreign states and their officials are immune from proceedings in the English courts, unless a recognised exception within the SIA applies. As a matter of domestic law, because the SIA is a complete code, if the case does not fall within one of the express statutory exceptions, the state is immune. And then there's a reference to Ben Kabouche, which I've already mentioned. And then there's a discussion of the relevant exception which was being considered by the court in that case. And then if you go on to paragraphs 21 and 22, please, at page 339, those are the critical paragraphs which are relevant to the issue today. If you start with paragraph 21, if state immunity is established, it is for a claimant to establish to the civil standard an exception to that immunity. So the exemption to immunity conferred by section 1.1 must be established to the civil standard. and then at paragraph 22, whenever the question arises under the SAA as to whether a state is immune by virtue of section 1 or not immune by virtue of one of the exceptions, the question must be decided as a preliminary issue in favour of the claimant in whatever form and by whatever procedure. So taking a step back, there are two important points of principle clearly stated in that case. Firstly, the existence or otherwise of an exemption to immunity must be established to the civil standard. And secondly, the existence or otherwise of an exemption to immunity must be decided by the court. And just briefly, to close the loop on the core of the court's obligations, if we could turn to London Steamship.
Sorry, just before we go to London Steamship, could you unpack for me the phrase "in whatever form and by whatever procedure" the court thinks is appropriate?
Yes, I think what that means is it has to be decided by applying the normal procedure of the court. So I'm not saying, for example, that you could never have a summary judgment if it was appropriate in the case. It has to be determined by the court as a preliminary issue. So if it's raised either by the court's own motion or by the state, it must be decided at the outset before anything else. And it must be done on normal, if I can put it that way, principles. And I think that's what the court meant when it said, in whatever form and by whatever procedure. The procedure available under the rules.
But why would that not include issue estoppel?
Because you can't do that by reason of section 1. Section 1 is different. Section 1 is, you can apply the normal process, witness statements, pleadings, whatever, or dispense with pleadings, whatever the court considers appropriate, but you can't have regard to issue estoppel.
Well, the issue for the court,
yes,
as I understand it, is did the Russian Federation agree to submit the dispute to arbitration? If it did, then section 1 drops out of the picture.
Yes, they satisfy section 9.
Yeah.
This exception is accepted, yes.
So that's the question for the court to be decided in whatever form and by whatever procedure the court may think appropriate. I'm not at the moment understanding why that necessarily rules out issue estoppel. Deciding the point by reference to issue estoppel, which is a normal procedure in our courts.
Yes, but it's not necessarily procedural. So there are two issues to that. One is we submit it's a rule of substance. And secondly, even if it were a rule of procedure, it is a rule of procedure that cannot be applied under section 1 of the State Immunity Act because it is not a determination, it is a conclusion that there is not an issue to be decided. And that's why. So ultimately that's the answer. And it's not about the general rules, it's something that stems from section 1 of the State Immunity Act itself. The court must determine it for itself and not conclude that it doesn't need to decide it because it's been decided by a foreign court. So your Lordship's right to raise that because there is a distinction between what process to reach that determination and a separate question is, can you have regard to issue of estoppel? And the answer to the latter is no. On the former, you can have whatever procedures the court considers are properly appropriate.
So if it were procedural,
yes,
if it were, then you could have regard to it.
I don't accept that. That isn't a point taken against me, but I don't accept that. If it were just a procedural rule, it would still be a rule which concludes that there's no issue to be decided, as opposed to the determination of the issue. So it doesn't. They don't get home. They haven't said a distinction. It doesn't, in my submission, make any difference at all to the conclusion. But you get there either way, and that perhaps explains why it hasn't been run. There are some cases that say it's procedural rather than substantive. I accept that, but it doesn't make any difference to my submission because my submission stems from section 1 of the State Immunity Act. The court must determine it for itself, and of course I've made it very clear. I totally accept that the building blocks will be there, usually will be there, because the issue of consent to arbitration will be an important factor in the jurisdiction of the tribunal. So there'll have to have been findings, usually by a tribunal, often by a court de novo again. They're there. I don't shy away from that. But the court can't rely on them.
How will they be relevant?
They're not. They're not. And it will be, on my submission, if the court were to take them into account, that would be improper and that would be a breach.
As I understand it, your point is that the English court must start with a blank slate.
Yes.
And decide for itself, did the Russian Federation agree to submit?
That's absolutely right.
To arbitration.
Yes, and that, as your Lordship probably aware, that happens in a different context under Section 67, which is the normal, if I can put it that way, process where a tribunal decides it has jurisdiction. The court has to consider that de novo, completely again. In fact, I did the first case under that, called case called Azov and Baltic, where it had never been done before under the new Act. There was a hearing before an arbitrator for 5 days, and the commercial court heard exactly the same evidence, same witnesses, same submissions, completely de novo. And that is the norm, as Dalla finds. Now, it's a different context, but it is a similar situation in some ways, that the court must decide for itself, and on whatever process is appropriate.
So is it right that it's critical on your submission that issue estoppel is a rule which means that there is no issue to be decided, rather than a rule which enables you to decide an issue?
I see what your lordship's getting at. Because there's no case in where there's a distinction between rule of law of procedure, our submission makes no difference. Whatever way.
I wasn't so much thinking about whether it's substance or procedure, but what its effect is. I.e., something which means there is no issue, or something which enables an issue to be decided.
Yes, I think the way I would put it this way, similar to a Section 67, it would be quite wrong for the court to give any deference to the findings of the foreign court, however one looks at it, however one cuts it. So you could analyse it as it's a rule of substance. It's a rule of substance that therefore the conclusion is there's no issue. The court cannot and should not have regard to the findings of the foreign court for the purposes of issue estoppel. And Section 9 requires a de novo review, so that you have no deference to that. The English court decides for itself. So, in my submission, it doesn't matter. It doesn't turn on the analysis of the nature of issue estoppel. What has to be done is the court must give a de novo autonomous determination under Section 9. I was going to go next, a case that I know your lordship is familiar with, London Steamship. That's in tab 22 at page 878. And just for the other members, that was one of the judgments which had come out of the sinking of the Prestige, which was an oil tanker carrying fuel, which sank off Cape Finisterre in Spain in 2002. And the case has given rise to a great deal of arbitration and litigation, including this court. And in this case, the shipowner's liability insurer brought a series of claims against France and Spain. And if your lordships go to paragraph 4 of the judgment, that's at 893. Paragraph 4, you don't need to look at it in any detail, but that is where the claims are summarised. And you'll see that it's quite a complicated case, but what I want to get out of it is rather less complicated. If you go on to paragraph 54, please, at 907. And in paragraph 54, that addresses, it's page 907, that addresses an argument advanced for the Kingdom of Spain. Namely, the authorities established that for immunity purposes, the merits of the claim had to be adjudicated upon on a final, not merely interlocutory or arguable basis. And counsel for Spain in that case was relying on J.H. Rayner Mincing Lane, which is, again, an authority well known to the court, and which I don't intend to show you, but the court rejected that reading of J.H. Rayner, and instead held, if it was there decided that where a state makes a claim to immunity, it is necessary for the court to determine on a final and not merely interlocutory basis whether the ground for immunity or loss of immunity exists. It was not the merits of the claim that had to be adjudicated, but the ground for immunity or loss of immunity. So that's quite an important point. So the scope of the obligation under Section 1 of the SIA, the court must determine or decide on the basis of balance of probability standard whether one of the exceptions to immunity applies.
But that doesn't really assist either of you, does it? I mean, if issue estoppel applies, then the court will have decided it on a final basis, not an interlocutory basis.
Yes, my lord, I accept that. If I'm wrong about issue estoppel, the building blocks are there. Yeah. So I have to accept that. but I'm not. But I think what's important to appreciate is that the cases all indicate that it must be a determination or decision by the court.
Yeah.
It must be on the balance of probabilities. Your Lordship's right that it all turns on whether or not an issue of estoppel is permissible. But in my submission, it plainly isn't permissible, or however one looks at it.
Yeah.
So I've taken you to the immunity of authorities. And the scope of the court's obligation in this regard is important because it's not just a question of the proper application of the English statutory obligation under the SAA. It's a question, as I've said, of the UK's international relations. Its obligation under international law to give effect to immunity, and for other states to reciprocate by giving effect to the UK's right to immunity before their courts were appropriate. In other words, under international law, there's a mutual obligation, which is not just that the state has immunity, but the other states are obliged to give effect to those other states' immunity under international law. And I've shown you jurisdictional immunities case to where that can go wrong. So coming back to the question of whether the court's obligation may be satisfied by reference to an issue of estoppel arising from a foreign court's decision, I just want to say a little bit about coming at it from the perspective of issue of estoppel. You've asked me about that. Because the problem we have, if I can put it that way, arises partly from the nature of issue of estoppel. And there are 2 points. The first is that issue of estoppel is a doctrine which binds the parties and not the court. That's a very important point. It's a very basic principle. I won't take you to an authority for it, but there is one in the bundle. It's the Virgin Atlantic case, volume D, tab 39, page 1463. I think it's Lord Sumption where he says there is a principle that even where the cause of action is not the same in the later action as it was in the earlier one, some issue which is necessarily common to both decided on the earlier occasion and is binding on the parties. I do want to show you one case, if I may, because I think it adds useful depth to that point, and that's Lord Hobhouse's judgment in Associated Electric and Gas Insurance Services. That's a volume A, tab 6, page 127. And while you're digging it out, I'll just explain what the case was about, because facts aren't particularly relevant. The underlying dispute was between 2 insurance companies that entered into an agreement with an arbitration clause. 2 disputes were referred to 2 separate panels constituted under the clause, and European Re wanted to show the award from the first arbitration to the Tribunal in the second arbitration on the basis that it created an issue of estoppel in that arbitration. And Aegis, the claimant, obtained an injunction in Bermuda, which was the seat of the arbitration, preventing them from doing so. And European Re, the defendant, applied to discharge it, and their application was refused at first instance. That decision was overturned by the Bermudan Court of Appeal, and then Aegis appealed that decision to the Privy Council, and it's the Privy Council judgment I want to show the court. One of the points which arose was that the effect of the injunction was to preclude European Re from raising the plea of issue of estoppel in arbitration 2, which European Re wanted to found the decision in arbitration 1. And if I can show you what his lordship said in paragraph 15, and that's at page 134, where he says that the making of an earlier award has conferred upon the successful party a right which is enforceable by later pleading an issue of estoppel. It's a species of the enforcement of the rights given by the award just as much as one would be a cause of action estoppel. It's true that estoppels can be described as rules of evidence or as rules of public policy to stop the abusive process by relitigation, but that's to look at how estoppels are given effect to, and not what is the nature of the private law right which the estoppel recognises and protects. In other words, where the court gives effect to an issue of estoppel, it's protecting or giving effect to a private law right of that party, which effectively prevents it from raising that issue again. And it's not a doctrine which binds the court. And I'll come on to that a bit later when we come to competing public policies. But for the second and more interesting point of principle on issue of estoppel is that a finding that an issue of estoppel arises is not a determination of an issue by the court. It's a finding that there is no issue determined. And for that, I just want to show you Lord Diplock's judgment in Mills and Cooper, which is in volume C, tab 23, at page 948. And while you're doing that, I'll just tell you a little bit about the...
Sorry, just give me the reference again.
Of course, yes. Bundle C, tab 23, page 948. and the facts are a little outdated and not entirely relevant, but I should tell you that what happened was the defendant had been found on the 22nd of December 1965 not to have been a gypsy for the purposes of Section 127 of the Highways Act 1959. The unfortunate word gypsy is the word that appears in the Act itself. Section 127 having banned gypsies from encamping on a highway. Now, the defendant was found not to fulfil that definition by virtue of the fact he was not of Roma ethnicity, and it was held he couldn't have committed the offence, the assumption being that the word gypsy in the legislation connoted an individual of that ethnicity. A few months later, he was picked up again and charged with the same thing. He said, well, I've been found not to have been Roma, and therefore not a gypsy for the purpose of the legislation on the earlier occasions, so the justices are now bound by that finding that I can't have been doing anything unlawful on the second occasion. As it happens, the question ultimately went against him on the basis that the word gypsy in Section 127 did not have a fixed meaning. You could be a gypsy at one time but cease to be one later, or vice versa, and certainly the word shouldn't be construed by reference to one's ethnic heritage. But in arriving at that conclusion, there was an important discussion of the nature of issue estoppel, and that, your lordships will find at page 468E of the judgment. That's page 949 of the bundle. Do you see that? The doctrine of issue estoppel in civil proceedings is a fairly recent and sporadic development, although none the worse for that. Although Hasted and Tax Commission didn't purport to break new ground.
Sorry, well, you're not...
Sorry.
Page 469?
468E.
468.
E, sorry. Page 949.
Yep.
Although Hasted and Taxation Commission didn't purport to break new ground, it can be regarded as the starting point of the modern law of modern common law doctrine, the application of which to different kinds of civil actions is currently being worked out in the courts. And then the description of issue estoppel. That doctrine, so far as it affects civil proceedings, may be stated thus: a party to civil proceedings is not entitled to make, as against the other party, an assertion whether a fact or of the legal consequence of facts, the correctness of which is an essential element in his cause of action or defence, if the same assertion was an essential element in his previous cause of action or defence in previous civil proceedings between the same parties. And then over the page is the critical bit. Whatever may be said of other rules of law to which the label of estoppel is attached, issue estoppel is not a rule of evidence. True, subject to the qualification I have stated, it has the effect of preventing the party estopped from calling evidence to show that the assertion which is the subject of the issue estoppel is incorrect. But that is because the existence of the issue estoppel results in there being no issue in the subsequent civil proceedings to which such evidence would be relevant. Issue estoppel is a particular application of the general rule of public policy that there should be finality in litigation. And so labels are not important to our case. It's ultimately what the ultimate effect is. But this case is pretty clear cut that what it does, what the effect of issue estoppel is to remove it as an issue. It has been determined, and the court looks at that determination. So I draw 2 points from that. Firstly, the effect of issue estoppel is to remove an issue from being in play. It's a summary determination, there is no issue. So it isn't a means by which...
Well, he's not quite saying that, is he? He's saying there's no issue to which such evidence would be relevant.
Yes. And
so you can plead in action number 2, I'm not a gypsy, and somebody else can say, well, you've been found to be a gypsy in action number 1, and that's my answer to the plea that you have raised. That is the issue for determination. You can't call evidence to dispute it, but there is still an issue to be resolved. What Lord Justice Diplock is saying, as I read it, is there is no issue to which the evidence will be relevant. Not that there is no issue at all.
Yes, I see that. I see that. But what I think ultimately my submission is that the court still has to determine the issue for itself. For Section 1 of the State Immunity, it can't have regard to the previous determination, however you look at it. So,
but if issue estoppel had applied in criminal proceedings, and if ethnicity had been the critical factor, both of which were prior points deciding the other way, then there would be an issue whether the defendant was a gypsy, to which, in effect, the previous judgment would be conclusive.
yes.
So he could call evidence until he was blue in the face.
And he wouldn't.
say the judgment was wrong, but the judgment's conclusive.
Exactly. And those, if I can put it this way, those procedural niceties of English law are nothing to the point on Section 1. So however one analyses it, the court, as here, faced with a Section 1 state immunity claim and an allegation that Section 9 applies, must determine that for itself, not shut out evidence.
The court does determine it. It determines that the defendant is or is not a gypsy by applying the principle of issue estoppel.
I understand that, and that's what was said below. But it isn't. That is not a permissible approach for Section 1, which is you cannot have regard to that. When the court determines on the balance of probabilities the Section 9 issues, it must do that for itself, de novo. In other words, it cannot have regard. It's put below as issue estoppel, so it cannot have. That's why we have used issue estoppel. It cannot have regard to an issue estoppel of a foreign court. It cannot give deference to that foreign court or that foreign court's findings. However you analyse it, it cannot do that. Now, part of our analysis is that it results in a non-issue. I stand by that. I can see why you say, well, you can't call evidence in response to that. You're shut out from doing that. If that is the effect, that's still not permissible under Section 1. So there may be many ways of analysing, and there are competing views in the various cases. I accept that. Nothing to the point here, because the point here is that the court must determine it for itself without regard to the findings of the foreign court. And whether that is by saying in some sense there is an issue, but evidence can't be called to gainsay it, and it's determining it on that basis, or saying that you're determining the issue but by reference to an issue estoppel, so it's a determination in that sense, applying ordinary English principles, that's a determination. That is not a permissible determination under Section 1. So that's the point. You cannot get around this by saying, well, English law takes it's a rather nuanced approach to issue estoppel. Is it substance? Is it evidence? It doesn't matter on our submission.
Yeah.
You can't get into those niceties.
You emphasise decision of a foreign court.
Yes.
Would the position be the same if it was a prior decision of the English court? You'll probably tell me that there are no circumstances in which that could arise.
No, not at all.
That it could.
No, because
is it the same point?
What I would accept is that if the English court determines of its own motion de novo, as we say it should, that can give rise to an issue estoppel in the English court. So if the court has determined that very issue de novo, it doesn't go on ad infinitum. If you haven't had regard to the foreign court's findings and the court's decided of itself, then that's a binding decision.
So the objection is not to issue estoppel as such, but to a foreign court.
The objection is to, yes, not having, I'll put it slightly differently, perhaps the other way around, it's not having a fully autonomous, independent de novo review by the English court on a balance of probabilities. If you have that, then the issue is met. But what you cannot do is have regard to a foreign judgment. There might be other circumstances that you couldn't have regard to, but the point is that the English court needs to do that de novo for itself. And subtleties, niceties, nuances about English approach to the doctrine of issue estoppel just don't come close to answering this point. It doesn't matter how you put it, frankly. You cannot do that. And the second point from Mills and Cooper is from that last passage, which is what is the purpose of issue estoppel under English law? And the issue estoppel is an application of the general rule of public policy that there should be finality in litigation. So it's an instrument which gives effect to an underlying public policy that you shouldn't just go on forever. There should be finality at some point. And I'll come back to that, if I may, when we're talking about competing public policies, because I think, in a sense, I've said the nutshell point, which is finality in litigation is a different scale of public policy to potentially putting the UK in breach of its obligations under international law. They're two very different. So if they do clash, in my submission, the answer is fairly obvious, that because one gives priority to the immunity issue rather than the finality in litigation issue. So that's the first of my three submissions. The second submission is and that can be stated rather shortly because there's clear court of appeal authority supporting it, although the authority does need to be contextualised to a certain extent. It's this. Firstly, exceptions to Section 1 of the State Immunity Act cannot be proved by way of an issue of estoppel arising from a foreign judgment, and that reinforces my first submission. It's an alternative way of reaching the same conclusion, not only on the terms of Section 1 itself and the independent duty of inquiry and determination it places on the English court, but on the idea that the SIA limits the jurisdiction of the English court. I want to start by referring the court to one of the leading commentaries on the State Immunity Act, and one that's regularly referred to and approved in this jurisdiction. It's Dickinson, Lindsay and Lunam. It's in the bundle in Volume D, at tab 55, page 1898. It's called State Immunity, Selected Materials and Commentary. Now, the paragraph I want to show you is 4.024, page 1898. So that's, this is a paragraph which isn't dealing with Section 1 or Section 9, but a different exception, Section 2. And that concerns the capacity of the foreign state to submit to the jurisdiction directly, which is another exception to adjudicative immunity. But it doesn't make any difference to the principle. Can I just remind you of the State Immunity Act under Section 2? I'll just tell you what it says so you don't have to turn it up. But Section 2.2 says, a state may submit after the dispute giving rise to the proceedings arisen, or by a prior written agreement. And Section 2.7 has a deeming provision. It sets out who may submit on behalf of the state. It says, the head of a state's diplomatic mission in the United Kingdom, or the person for the time being performing his functions, shall be deemed to have authority to submit on behalf of the state in respect of any proceedings. And any person who's entered into a contract on behalf of or with the authority of the state shall be deemed to have authority to submit on its behalf in respect of proceedings arising out of the contract. Now, in addressing those provisions, Dickinson is very clear. It says, this deeming provision appears to be intended to resolve doubt as to whether the persons listed have authority to submit. In other cases, the authority of the state's representative must be established by evidence if challenged. And then the crucial bit, in such cases, there can be no question of ostensible authority, this being a species of estoppel and incapable, therefore, of extending the court's jurisdiction. And you'll see in the footnote the particular case is referred to, that is Ahmed and the government of Saudi Arabia. And in order to understand what Dickinson is driving at, I'd ask the court to turn that up. It's in the bundle, Volume A, tab 1, page 7. And in some senses, while you're turning that up, I'll just tell you a little bit about it. That was a straightforward but illuminating case. The applicant was a British national who commenced work without a written contract at the Defence Office of the Embassy of Saudi Arabia in London, against which she wished to bring a claim of unfair dismissal. Now, self-evidently, as an emanation of the Saudi state, the embassy had the benefit of immunity under Section 1, pursuant to Section 14 of the SIA. And the applicant sought to remove that immunity by reference to Section 2.2, claiming that the embassy had submitted to the adjudicative jurisdiction of the English courts by a prior written agreement. And the basis of that argument was that at a meeting between the embassy's local staff and the military attaché, she received a copy of a solicitor's letter addressed to the attaché, in which the attaché was advised that local staff would have rights under English law, and an industrial tribunal could award compensation for unfair dismissal. The question in issue was whether, in distributing this letter, the attaché was acting with the ostensible authority of the embassy, and thus was deemed to bind it under Section 2.7 of the State Immunity Act. And the applicant further said that the letter constituted a submission in the sense of Section 2.2. The industrial tribunal held for the applicant, but that was then overturned by the EAT, and from then the matter went to the Court of Appeal. And those are the basic facts. Now, there was also a further argument, Section 16 of the SIA, and employment contracts of members of the mission, but that isn't relevant here. And if you could go to the report at page 14, which is the judgment of Lord Justice Peter Gibson, page 32H. And His Lordship starts the analysis. The applicant's contentions before the Industrial Tribunal were that the letter of the 16th of November 1990 constituted a submission to the jurisdiction It was distributed to the staff by the authority of the military attaché. Delegated to her assistant, the term written agreement in section 2.2 did not necessarily mean a binding contract. The intention of the letter was to make the staff believe they'd be protected by English statute law. The two industrial members of the Tribunal accepted these contentions, their reasons being as follows. And then he says, in the absence of any statutory definition of written agreement, they consider the solicitor's letter and the circumstances in which it was written amounts to a written agreement within the meaning of the Act. They would add, in effect, that Saudi Arabia is stopped from denying that it had submitted to the jurisdiction, and it would be unjust to deprive the applicant of a remedy in all the circumstances of the case. So that's where the estoppel argument comes in, and over the page, Lord Justice Gibson goes on to consider the arresting estoppel point immediately. The point on estoppel was not one raised by the applicant and was supported by her before the employment of a tribunal, nor before us. No doubt because it is clearly established that an industrial tribunal may not enlarge its jurisdiction on the basis of an estoppel. And then his lordship refers to Employment Secretary and Globe Elastic, which is a decision of the House of Lords. That's in the bundle. You don't need to go to it. It's at tab 32. And his lordship says, even if anything in the nature of an estoppel arose, that could not confer upon the tribunal a jurisdiction beyond that given by the Act. Whatever force it might have...
Sorry, where are you reading now?
Sorry, that's... this is the passage from Lord Wilberforce in Employment. I'm just going to tell you what he says rather than turn this up.
Well, I think I'd rather have a look at it.
Of course.
Because what Lord Justice Peter Gibson says is hardly strong authority, since he says it wasn't raised, it wasn't supported.
Yes.
So I think we better look at
of course,
what does establish it.
Yes. It's in tab C, tab 32. So volume C, tab 32, page 1261. Yeah. See, and so, do you see that at 1261, 519A, the judgment, even if anything in the nature of an estoppel arose, do you see that?
Yes.
That could not confer upon the tribunal a jurisdiction beyond that given by the Act. Whatever force it might have as between employer and employee, it could not make the redundancy payment agreed upon, a payment which the employer was liable under Part 1 of this Act to pay, and so could not create a right of rebate. Most important passage, putting this in another way, a personal estoppel as between employer and employee, which is the most this could be, could not bind the Secretary of State. So that last sentence is particularly resonant in my submission.
So the argument is the SIA limits the jurisdiction of the English court. That jurisdiction cannot be enlarged by an estoppel.
Yes.
Therefore, issue estoppel can play no part in the court's decision about whether or not
it has jurisdiction.
The state has immunity.
Exactly. So I just want to make a few points about Ahmed, because there are some points of distinction. The first one is, it could be said against me that Ahmed relates only to the restricted statutory jurisdiction of the Industrial Tribunal. Because obviously this arises where you have a tribunal which only has a statutory jurisdiction, unlike this court, which has an inherent jurisdiction.
But your point about that is that I think, as I sort of summarised,
yes.
The court doesn't have unlimited jurisdiction. Its
yes.
jurisdiction is limited by the SIA itself.
That is absolutely right. So it's not a difference in principle, and that reflects the character of state immunity in international law, which I mentioned at the outset, Holland and Lamford and Wolf. It is not a self-imposed restriction on the jurisdiction of its courts. It is a limitation imposed from outside. So your lordship, I think your lordship has the point. I can move on. So the principle applies, and then there might be said, well, there is some distinction to be drawn between ostensible authority and some other form of estoppel. But again, in my submission, that is nothing. There is nothing in that distinction. It is about enlarging by reference to any form of estoppel. I should just show you, just to finally make my points on here, that a further case called Yemen and Aziz, Just if you could turn that up quickly, that's in volume C, tab 31. This case was referred to Mrs. Justice Cockerill. It wasn't addressed in the judgment. The facts are similar. It's tab 31, page 1230. The applicant was a staff member of the Yemeni embassy in London who also made an unfair dismissal claim in the Industrial Tribunal against the embassy and Yemen, and by extension Yemen, which had the benefit of adjudicative immunity under section 1.1. The embassy solicitors, purporting to act on behalf of the embassy, entered a notice of appearance and grounds of defence. And it's obvious on its face that the filing of such a notice and grounds, if valid, constituted a step in the proceedings otherwise than for the purpose of claiming immunity, so that they could arguably constituted a submission to the jurisdiction of the courts of the United Kingdom under section 2.3b of the State Immunity Act. But there was, however, a real issue as to whether the solicitors, in filing the notice and the ground, were acting on the instructions of the head of the mission, as in Ahmed. And the reasoning of the Court of Appeal really starts at paragraph 53 at the judgment of Lord Justice Pill at page 1245. And what your lordships will see there is that straight away his lordship approves the statement in Dickinson and the terms in which it's given. In such cases, there could be no question of ostensible authority, this being a species of estoppel and incapable, therefore, of extending the court's jurisdiction. Then discusses, as in Ahmed, the importance of section 1 and the operation of section 2.7 in paragraphs 55 to 57. But he doesn't do so in terms of the specific jurisdiction of the Industrial Tribunal as a statutory body, but in the terms of the SIA generally. And with respect, and as we've seen, this is the correct analysis, given that under section 1.1 and section 22.1, the SIA doesn't distinguish between the Industrial Tribunal or any other English court, including the High Court. And if you look next at paragraph 58, you'll see Lord Justice Pill say, I do not consider that the doctrine of ostensible authority applies either to the solicitors or to Al-Qaeda, or that jurisdiction can be created by an estoppel. The state has protection against unauthorised action taken by a solicitor or a member of the mission. Again, a very broad general statement, not limited to the Industrial Tribunal or the Employment Tribunal. He then continues, the employers were entitled in the circumstances to assert before the Appeal Tribunal there had been no waiver of immunity under section 2 and hence no jurisdiction, because the earlier steps in the proceedings were not steps taken by the state. As already noted, it is necessary to determine the factual issue arising in order to decide whether there's been a waiver under section 2. And we submit that logic applies similarly to a case as here under section 9. And if you look at 60, Lord Justice Pill says, I'd add that the duty of the courts under the 1978 Act to inquire is not confined to whether under section 2 the state has submitted to the jurisdiction of the courts. Under section 1.2, effect must be given to the immunity conferred by section 1.1, even though the state doesn't appear in the proceedings. It follows that where a party to proceedings may be a state within the meaning of the statute, inquiry is necessary into whether that entity party, if entity party to the proceedings, though not present, has that status. So, as I say, similar logic to section 9. The court is obliged to look into the matter itself and cannot allow an estoppel to get into the way of determining that question as to whether there has been an actual agreement to arbitrate. So, although there are differences in facts between Ahmed and Aziz, we submit the logic of those decisions applies equally here. And we say that second argument is powerful affirmation of the principal case that we set out on the nature of state immunity and its interaction with issue of stock. So that is a separate ground, but they do go together, one and two. You could find for us on the first ground, we don't need to go any further, but this is self-standing separate ground. They all go to the same point. Though they all converge on a separate point, a single point, which is that the English court cannot rely on an issue of estoppel. It cannot have regard to the findings of a foreign court to determine whether one of the exceptions to the state's adjudicative immunity in section 1, and in this case section 9, has been met. And it doesn't matter about the precise definition or nature of the issue of estoppels. The English court has to do it autonomously, de novo, for itself. I just, at this stage, would like to just take you, your lordships, to the judgment, just to say why it is we say the judge reaches the wrong conclusion. To be fair to the judge didn't have these cases and these submissions, but that's in tab 3 of the core bundle. And the relevant part starts at paragraph 30. And if you look at paragraph 3, what the judge notes is the starting point, there is no clear authority on this point either way. And that's right in the sense that the significant question of the interaction between state immunity on the one hand has never before now been considered by English court, which is why we're currently before this court. But the fact that there isn't an English authority on this point, we suggest, indicates that we're right, because the issue will always arise in the not unusual situation where a state's involved in a foreign-seated arbitration and jurisdiction is challenged. It's something that arises in the ordinary course. And so one would have expected, if the respondent were right, for there to be authority on this point. And then the judge goes on to say, the balance of authority tends to favour the claimants, in that there are two cases which implicitly recognise the possibility of initial estoppel against a state. Now, with respect, that's not the right question, because you can have issue estoppel against a state on the merits. I think one of the cases in the bundle was MRG and Matlin Patterson. It's plain that you can have that. The question is in relation to state immunity, because, as I've said, that the nature of the act itself gives rise to different questions. So the question is to ask whether there are cases that recognise or indicated that under Section 1 of the SIA, the English court can avoid making a determination of the balance of probabilities by reference to the prior decision of a foreign court. So it's not simply whether you can have issue estoppel against the state generally. So it's not, we are not submitting that you cannot have in any case an issue estoppel against a state, that it can never arise.
So your point is that if the English court has jurisdiction over a state, then issue estoppel may apply as between the parties, but doesn't apply to the preliminary question whether the English court has jurisdiction.
Exactly. And it stems from the nature of Section 1, as I've already explained. And that's the difference. It's not a general question. And if the English court were fully and properly to determine state immunity, as we say it should do on a balance of probabilities without regard to, then that would determine that issue. And so what the judge, in the judgment, discusses the case of Dalla Real Estate and Diag Human. That's at paragraphs 32 to 35. Now, neither of those cases were concerned with Section 1 of the SIA. They were concerned with questions that arise under the Arbitration Act after the jurisdiction of the English court had already been established. And specifically, they concern the question of whether a state, or any party for that matter, in resisting enforcement under the Arbitration Act, Section 103, can be prevented from raising a defence to enforcement on the basis of an issue estoppel by a foreign court. And with respect, that is not the same point at all. And one simply doesn't get any real answer at all from those cases. As I've explored by reference to the Corinna Suzanne and the London Steamership case, Section 1 imposes on the English court an imperative duty to decide for itself on the balance of probabilities whether any exceptions apply. No more and certainly no less is required if the English court is to take jurisdiction over the foreign state. And then Associated Electric and Mills and Cooper, the nature of the issue estoppel, it only binds the parties, it doesn't bind the court. Either it prevents a determination at all, or it has some procedural mechanism by which you can't put your full case. All of that is impermissible on our analysis. But none of those considerations which are before your lordships on the issue in hand arise when determining what a state is entitled to do under Section 103. That is not concerned with an imperative duty in any way similar or comparable to Section 1 of the State Immunity Act. So those cases simply are not apposite. And they're also rendered inapplicable by reference to my second argument, which is the nature of the jurisdictional barrier imposed on the court by Section 1, i.e. a jurisdiction that comes from outside, not from within, i.e. the cases Ahmad and Aziz. So we submit that it is right to say there's no authority directly on point, but in our submission that tends to indicate that we're right rather than we're wrong, rather than it being going both ways, because it's something that would have arisen in many other cases, and if that were the position, it would have been determined before. But the cases relied on don't take.
Well, it might or might not have been. See the Singapore case, in which all sorts of other points were taken, but not that one.
In a sense, then yes. if you reject that submission, we then move on to what authorities did the judge rely on, Dalla and Diag. They don't help you at all. They don't take it any further forward. They don't actually engage with the issues that are before your lordship. So they don't tell you anything. So in one sense, then yes, but none of those cases in the judgment actually address the issue that your lordship's going to have to grapple with. And then if I could just show you what the judge says at 39, page 26. What the judge says is, this is a point which also emerges from actual consideration of the SIA. There is nothing in it which disapplies procedural rules or substantive rules which would otherwise apply. There is no reason interior to the Act which would make issue estoppel applicable to a question which arises vis-à-vis state. Now, the immediate response to that is provided by our second argument, Ahmed and Aziz. An English court can't rely on an estoppel, including an issue estoppel, to verify that one of the exceptions to Section 1 of the SIA has been made out. In those cases, the relevant exception was Section 2. In the present case, the relevant exception is Section 9. But in both cases, the result is reached as a matter of principle. No estoppel can be used to extend or expand the court's jurisdiction. It's limited by the SIA. And in my submission, that alone is sufficient to provide a reason interior to the Act, which would make issue estoppel inapplicable to a question. Now, to be fair to the judge's reasoning, the judge didn't have these cases and didn't have submission in these terms. So one can see why you might be led into error, into thinking, well, you just look at, there's nothing in the Act and you can just do the normal, take the normal approach. But beyond that, the reason is found in Section 1 itself, as subsequently and consistently interpreted by the intermediate and final appellate courts of this jurisdiction. That case law confirms that Section 1 imposes on the English court a mandatory duty in imperative terms to determine for itself the civil standard whether a foreign state's adjudicative immunity is abrogated by one of the exceptions. And you've seen jurisdictional immunities, why it's so particularly important. And then on the nature of issue estoppel itself, firstly, it operates between the claimants, between the parties. It cannot bind the court. It may be a restraint on pleading. It may restrain the issue being raised or evidence being put in relation to that issue. But in one sense, it's having, whatever sense it is, it's having regard to a determination by a foreign court which is impermissible. What is required under Section 1 is for the English court to determine for itself de novo autonomously. Thirdly, particularly because of the consequences, the very severe consequences, if the court is wrong, if the court has regard to the foreign court's decision, you could potentially put yourself in breach. The court could put the UK in breach of its obligations under international law. So we submit that is something that the SIA itself precludes. It is inherent in Section 1 that you cannot have deference or regard to the findings of the foreign court. So then, my Lord, next is Section 31 of the Civil Jurisdiction Judgments Act 1982, which is our ground 3. That's dealt with in the judgment at paragraph 40 at page 26. Finally, stepping back to the point about the duty to give effect to the immunity confirmed by the SIA, this can only cause a problem if the effect of the issue of estoppel generally is to preclude considerations of state immunity. I think it's like Lord Justice Males's point. Well, in one sense, it's a determination because the court's deciding, but it's deciding it by reference to the decision of the foreign court, be that issue estoppel or some other basis. And so in one sense, as a matter of language, you say, well, there is a determination. It's just, I think that was where it was put below by my own friend, which is we're asking the court to decide state immunity, but the court can decide that by reference to issue estoppel. It was all put as issue estoppel. So the judgment, what the judge says is, but just pausing there, sorry, on 40, it does prevent the foreign state from raising the issue. And in that sense, it is either a non-determination or a determination by reference to the findings of the foreign court. And that is contrary to Section 1. And then at 41, the judge addresses Section 31 of the CJJA. And the provisions set out there in paragraph 42, she rightly says that the effect of the provision is you can enforce a judgment, but only if you've got it here. Now, pausing there, if what the claimants were attempting to do was enforce the judgments of the Dutch courts, consideration of that provision would be warranted. It's an exception to state immunity for a unique category of case. But the claimants here are not attempting to enforce a foreign judgment. They're attempting to enforce the award. That's an entirely different thing and governed by Section 1 and Section 9 of the State Immunity Act. So the first question is, why is Section 31 of the CJJA even relevant to this question? And the judge's answer, paragraph 44, adopting the respondent's case is, what the claimants are doing is invoking the common law doctrine of issue estoppel and the test applying that doctrine. So you can see below it was all put as issue estoppel. However, they concede that because that involves as part of the exercise a recognition in substance of a foreign judgment against the state, the Section 31 test must also be passed. And as the logical corollary, they say, if we could have applied for enforcement recognition, why should issue estoppel not be available? Now again, that is to ask the wrong question. The exception to adjudicative immunity is that the claimants rely on Section 9. The applicable rule here is Section 1 of the SIA, not Section 31 of the CJJA. And the exception that the claimants rely on is Section 9 of the SIA. And as held by Mr. Justice Butcher in Tatneft, that requires an independent de novo consideration as to whether the foreign state and the claimant have entered into an arbitration agreement. Just to remind you what he said, if there's an issue which is either apparent to the court of its own motion or raised by the state, and which goes to the question of whether there was such an agreement in writing in relation to the relevant dispute, I consider the court's obliged to consider it. It can only exercise jurisdiction over the state if it's satisfied that Section 9 exception is nevertheless applicable. It's very difficult to see how Section 31, which is a statutory provision dealing with a completely different situation of recognition and enforcement of judgment, can add to or overcome that analysis. So our primary case is it's completely irrelevant.
Can I put a hypothetical to you?
Yes.
Suppose that a foreign court gives judgment against the state for damages for breach of contract.
Yes.
Suppose. And the claimant, who's got the benefit of the judgment, comes to this country and says, I want to enforce this judgment. Can the state say, the English court has no jurisdiction because this wasn't a commercial contract at all? It can raise that again?
Yes, under Section 31, because it says that under 31, you have to show that that court would have had that there is no immunity.
That court's decided. That court has decided this was a commercial contract and gives damages for breach of contract.
Yes.
But on your analysis, when that judgment comes to be enforced in this country, recognised in this country, the state can say, well, the foreign court got it all wrong. This never was a commercial contract, therefore you, the English court, don't have any jurisdiction.
Yes. And that's what happened in Argentina. That's what happened in ML in Argentina. You go under 31, it's a different regime, but built into that regime is the question of whether or not there's a specific provision for the state immunity issue. Under 31. But my point here is, just I put that to one side for a moment. I'll just finish what the judge said about this, because it doesn't answer the question anyway, and I'll explain why in a moment. Just see what the judge says about this at 49 and 50. What is said there, the remaining question on state immunity is therefore whether this proviso is satisfied, whether the Russian Federation would not have been immune if the Dutch courts had applied rules corresponding to Section 9. The claimants say that the Russian Federation is caught by this inter alia because it submitted to the jurisdiction in the Netherlands by challenging the awards in the Dutch courts. So of course that would be a normal situation, which is the state loses, it's the court and tribunal held that there was consent, and then the state challenges that, and in order to do that they obviously have to submit. The Russian Federation initiated proceedings in the Netherlands. In this jurisdiction, that would be caught squarely by Section 2.1. So if the Dutch courts applied Section 9 in mutatis mutandis, there would have been no state immunity. That logic appears perfectly sound. But with respect to it isn't sound. Dutch courts didn't apply Section 9, mutatis mutandis, or at all. They applied Section 2.1 of the State Immunity Act. And in these proceedings, Section 9 is the exception to Section 1, relied on by the claimants, and not Section 2.1. And what this analysis amounts to is a situation which the claimants are effectively seen to be saying that as the Russian Federation started the Dutch proceedings, the English court should be acting as though the Russian Federation started these proceedings as well. and somehow that meets Section 9. And that logic just simply doesn't apply. The short point is that even if they had applied under Section 31 for the judgments to be recognised, they would be no further forward, because they just have the judgments. Assume they have the judgments. One then looks at the application to Section 1. You can't have regard to either the judgments or the award for the purpose of issue estoppel or the findings. And taking those into account, the court still has to determine this de novo autonomously. So it doesn't give rise to any answer. We say it's completely irrelevant. It doesn't take the matter further forward at all. But even if they had done that, again, it wouldn't take the matter any further forward, because they just have similar to the award, which is what they're seeking to enforce, they'd have the same findings in the judgment. But they can't rely on those for an issue estoppel. We don't know what the response to that is, because nothing's been put in writing, but I anticipate that they will say something about 31. But
just going back to the judgment for a moment.
Yes.
The submission that Mr. Qureshi made at 47, he said any reliance on the foreign judgment should be via this process rather than via issue estoppel. Claimants should have applied for recognition and enforcement of the foreign judgments. But you say that there's nothing in that argument because recognition of the judgment doesn't get them anywhere.
Yeah, it doesn't get them anywhere anyway. I think Mr. Qureshi was fairly saying, well, you can't circumvent the process by just saying we would have done this and you should take it into account. I don't resile from that at all. That's absolutely the case. But they don't get anything out of it anyway. Yeah. It doesn't improve their position one way or another. It makes no difference. Just so your Lordship appreciates, Section 31 of the CJJ is for the purposes of recognising and enforcing judgments. Section 1 and 9 is for the recognition of arbitral awards. And you've got my points on 1 and 9. Now, if I'm right about that, see, the oddity of 31 is, if I'm right in my submissions, my 3 points, primary case, they don't need 31. But if I'm wrong about that, they don't improve their position by 31 at all. But it doesn't take them anywhere. And you haven't seen anything grappling with the primary arguments because we put in our skeleton in December.
Yeah.
But that's really the nub of it. 31, in my submission, is a red herring. It doesn't improve it anyway. There are procedural objections that Mr. Qureshi made quite a lot of, which is you can't pray and aid something you haven't done. You're applying for the recognition of the award. You know, how does it work? The logic isn't there. The logic seems to be a prejudicial one, which is the building blocks are there. They're against the Russian Federation. Therefore, if the court had been asked to determine state immunity under Section 9, it would have concluded that the state didn't have immunity because it consented to arbitration. It's really a prejudice point. It doesn't go anywhere. As I say, if we're right about issue estoppel, it doesn't take them anywhere. If we're wrong, they don't need it. Well, that was really, I think, what all I wanted to say. Oh yes, sorry. State immunity is public policy. I think I've sort of said 3 propositions. Let me just give you the 3 propositions. Firstly, state immunity and issue estoppel reflect rules of English public policy. They both reflect the rules of English public policy. Second, if there is a conflict between the 2 rules, that conflict should be resolved in favour of state immunity for the reasons I've given, which is that they're on a different level. And thirdly, in this case, if and insofar as the 2 collide, then it's state immunity, not finality in litigation and estoppel.
Well, that's the same as your second point.
The 2 are allied. Maybe I should just show you one Spencer Bauer. We put it in our writing, but if you just turn to Spencer Bauer, Volume D, tab 56, page 1909, paragraph 1720. Spencer Bauer accepts the general principle that one public policy can be trumped by another.
Sorry, just give me the again.
Volume D, tab 56.
Yeah.
Page 1909. So if I just take your Lordships that, do you see in paragraph 1720, the public policy in favour of the finality of judicial decisions reflected in the res judicata doctrine may be trumped by the public policy against the enforcement of illegal contracts. So in other words, what that illustrates is the general principle that one public policy may trump another. In this case, I would suggest that it's rather more easy than in other cases, because the fundamental difference in the nature of the public policies and the fact that state immunity emanates from a different plane. I was going to spend a bit of time going through man sugar, but I don't think I need to. I think your lordships have the point. That's the case that Spencer Bauer cites at footnote. You have it in the bundles, and we put our case on that in writing. But I don't think I need to take up time with that now. So in a sense, that's the nub of our case. So our three primary points are as to why under Section 1, it's inherent in that section that one cannot have regard to findings of a foreign court by way of issue, estoppel, or frankly on any other basis. The court has to do that de novo. Now, if I'm right about that, we have grounds 4 and 5. They don't really arise. We don't need them. But I should probably say just a little bit about them. We set out our position in writing on those. Before I do that, I just wanted to make sure that your lordship's happy with the primary case. Is there any questions arising out of that? Because as I say, that is the nub of the appeal.
Thank you very much, Mr. Flynn.
So really, we're then on to special circumstances. And what your lordships will have seen is that we have added a ground. And the reason we've added a ground is because we've added the primacy which ought to be given to the exceptional nature of state immunity. And the reason for that is really this. Our case is very much that our primary case succeeds. We don't need to get into grounds 4 and grounds 5. But there is a theoretical possibility that you might say that issue estoppel applies, but it is to be treated as a special circumstance. So we've simply given you that option if you reach that conclusion. Now, what I would say is that is very much...
I don't see how that differs from...
No, exactly.
Because if it's always going to be a special circumstance that
exactly.
Issue estoppel involves state immunity, then it's the same as saying it doesn't apply.
Exactly, and I'm very far from encouraging you to go down that route. It's simply there just in case during your deliberations you reach that conclusion. We didn't want you to say that you couldn't go down that route, but I absolutely accept that. The other grounds on special circumstances are in the grounds there because of the extant fraud challenges wherein the awards are liable to be set aside and the existence of a potential CJEU reference and determination that there was no jurisdictional basis for the awards. Now, the issue of special circumstances arises from Arnold and NatWest. That's in the bundles. You don't need to turn it up. But the general principle is this, that a bar created by an issue estoppel is not an absolute bar. This is ordinary principles, non-state principles.
Yeah.
And an inflexible application of it shouldn't be avoided. Should be avoided if it would lead to an unjust outcome. And 4.1 and 4.2, that is the fraud and the reference, are prefaced on issues that are pending before the Dutch courts. And the Russian Federation's allegation is that the arbitral tribunal's findings on jurisdiction were obtained by fraud. That's ground 4.1. And we also have requested that questions regarding the interpretation of the Energy Charter Treaty be referred to the European Court of Justice, the Court of Justice of the European Union, and that's ground 2. And those issues are central to jurisdiction. Now, the Dutch proceedings have a somewhat complex procedural history. The current position is that those two issues are the subject of a cassation appeal to the Dutch Supreme Court that was filed on the 17th of May 2024. And we say those questions remain open.
So this is after the Amsterdam Court of Appeal gave judgment? There's an appeal against that?
Yes.
Right.
Yes. So what our position, in a nutshell, is this. Those questions, fraud and reference, remain open in Holland. And we say that should lead this court, even if you were against me on my primary case. So these are all issues that only arise if you're against me on the primary case. But you should be very cautious in asserting jurisdiction over Russia in those circumstances where those are extant. There is a general caution on the basis of foreign judgments within issue estoppel. But we say where you've got these open questions in a case of this nature, one should be extremely cautious. The decisions below found jurisdiction on the basis that Section 9 of the SA applies. In other words, that the tribunal had jurisdictions but the decisions were reached below on the basis of an issue of stock law arising from the Dutch court's decision. And so we submit the court should be very slow indeed to rely on those issue of stock laws.
Can I just go back a moment? The Dutch Supreme Court rejected all the challenges to the validity of the arbitration award, except that they said that the Hague Court should have entertained the fraud point. And the fraud point, as I understand it, relates to the way in which the arbitration was conducted and an allegation, in effect, that the claimants bribed one of the witnesses.
Yes.
The Dutch court was asked to and refused to make references to the CJEU.
Yes.
How could a reference to the CJEU possibly arise if even if the fraud case were to be successful on appeal? I mean, that's simply to do with the conduct of the arbitration, isn't it? How can that affect the meaning of the treaty?
Well, both of these cases could go to the enforcement of the award. So it could have an impact on the enforcement.
No, I'm not asking that question. How is there any realistic possibility of a CJEU reference when the only extant appeal is against the finding that there was no fraud or no relevant fraud? What issue treaty interpretation?
I'm not sure I can. I'm not sure I can give you a sense of sort of the percentage chance, but I'll see what I can do. Might be best to do it by reference to the judgment, I think.
This is Justice Cockerill.
Yes.
Judgment.
Yeah. So if you go to the judgment at paragraph 95.
Yeah.
The RF contends that any determination of the Dutch judgments on set-aside, grounds 2, 3 and 5 remain subject to potential, in the words of its expert, significantly probable referral by the Amsterdam Court of Appeal to the CJEU for rulings on the interpretation of the ECT. So that our expert says it's significantly probable. And then if you look at 98, the RF says that an answer to these questions divergent from the interpretation of the ECT in the DSC judgment could realistically cause the Amsterdam Court of Appeal to annul the awards on the grounds the dispute was not subject to arbitration. Now, it will obviously be said against me that we lost on that.
I don't at the moment see how there could possibly be treaty questions arising out of an allegation of fraud.
They're separate. The two issues are separate. There's fraud, i.e. the bribery, and there's a separate issue about the construction of the ECT, the Energy Charter Treaty. So they're two different strands, separate and distinct.
But there's nothing left in the Dutch proceedings in relation to the other issues, is there?
They're the subject of a cassation appeal to the Dutch Supreme Court.
On the question of fraud?
On both, I think.
Well, that's the only issue that was remitted to the Court of Amsterdam.
I'll just take.
I don't think this is going to be your strongest point.
Well, no, my lord. I was trying to take it as briefly as possible because I do think that I completely see that. I mean, if you're against me on my primary case, I can see. Can I just clarify? Yeah. My instructions are that but I can't give you any more detail, that both these grounds are still alive. So I can't take you any further forward than that. As you say, I think I'll take it very shortly, because if they are extant, that again is a separate reason. So if you're against me on it, this is all in the context. You're against me on the primary case. I've lost that. And whether there are exceptional circumstances. Those 2 points are still a possibility at the very least. And in those circumstances, I would submit that the court should be extremely cautious about giving effect to initial estoppel in those circumstances where there's still the possibility of it being overturned or annulled or affected in some other way. This is an enormous case. And it's still a possibility that it could be set aside in the future. That's still possible.
Well, I suppose that's part of the question, whether the judgment so far is conclusive, which is one of the ingredients of the issue of estoppel. And I suppose you might say, well, if it's still liable to be set aside on the ground that the award was fraudulently procured, you can't say that.
Yes. And I have to be
so far are conclusive, final and conclusive.
I have to be careful about that, because I would accept that. I think what will be said against me is it doesn't go to the jurisdiction and the clause itself. And I don't accept that's an inevitability, but I do see the force of that. And I think that's the highest I can put it. The only other point I would make, I think, on ground 5 is that we are in the territory of an international treaty. And that is a further ground for caution. And the reason I say that is this. This court has to reach a conclusion on the autonomous meaning of the Energy Charter Treaty. And no national court has a final say on that. In other words, if it is a disputed construction, it is not a simple thing for this court or indeed any national court to reach a conclusion on that. So it is not something that I could say precludes the application of an issue of estoppel in all circumstances. If the treaty is clear, that would be a different matter. But where there are issues about construction, that is an important factor in my submission, militating against its application in the particular case, and really caution upon caution upon caution once we get to this stage. So although, my lords, this is only something I can only push so much, and I can only put so high, where there is a disputed treaty interpretation, one, in my submission, should also be extremely cautious about applying an issue of estoppel where no national court has a final say at all. It's not a matter for a national court. So if there is a disputed interpretation, that puts further caution. But I don't think I can put it any higher than that. So, my lords, that was all I was going to say on the other grounds. Really, the nub of this is the issue of estoppel. So those are my submissions, unless I can assist your lordship further.
Thank you very much. Very economical, Mr. Flynn. Yes, Mr. Crowe.
Thank you. We were going to address you under broadly 3 headings, 4, 3.5. I was going to identify what is and is not in issue first, Secondly, to address the three main points. Thirdly, to address the residual points, grounds 4 and 5 essentially, and then make some wrap-up conclusory remarks. So far as what is and is not in issue, I wanted to start with what is not in issue. There has never been any dispute between these parties that a foreign judgment can, in principle, give rise to an issue estoppel against a non-state party. That's the first instance judgment at paragraph 20. Secondly, there has never been any dispute between these parties about the applicable legal test for giving effect to a foreign judgment by way of issue estoppel against a non-state party. The third point is that the judge below held that the Dutch judgments, using, if I can make them audible, the capital letters, referring to the combined effect of the Hague Court of Appeal judgment and the Dutch Supreme Court judgment that we do have. The combined effect of the Dutch judgments we have already is that the Dutch courts have finally and conclusively determined that the tribunal had jurisdiction to issue the awards. That is paragraphs 64 to 112 of the judgment below, and there is no appeal against those findings. The fourth point is that the judge below also held that the Dutch judgments satisfy all the other requirements for an issue estoppel based on a foreign judgment against a non-state party. And her conclusion is in paragraph 113 of her judgment, and there is no appeal against that finding. And the final point is that the judge below held that the Dutch courts would have had jurisdiction to issue the judgments that they did if they had applied English law on state immunity, as my learned friend just took you to the relevant paragraph, because Russia initiated the challenge in the Dutch courts. So applying the English State Immunity Act to that fact situation, the Dutch court would have had, if it had been applying the State Immunity Act, would have had jurisdiction to issue the judgment that it did by reference to Section 2 of the State Immunity Act. And that is not a point on which my learned friend appeals. So the result of that combination of factors is that the issues that are before you have to be decided on the basis that the Dutch judgments would give rise to an issue estoppel if the defendant had not been a state party, had not been a foreign state. And we do submit that the English court is bound to give effect, is bound to recognise the Dutch judgments by virtue of Section 31 of the Civil Jurisdiction and Judgments Act. I will come back to the detail of that, because I have to admit at the moment I don't actually understand my learned friend's oral submission on that point. But our case is that the English court is bound, by reason of what has been decided in the court below and has not been appealed, the English court is bound to recognise the Dutch judgments. Now, that being the framework for the debate of what is in front of you, we submit there is, in fact, nothing in the appeal. If there is a foreign judgment which ticks all the boxes for an issue estoppel based on a foreign judgment, an issue estoppel as against a non-party, and if the English court is bound to recognise the foreign judgment under Section 31, that's the end of the case. And although both in writing and orally...
What does Section 31 add to your case? Assume all the Carl Zeiss criteria are satisfied, as the judge found, and it's not now in dispute. What does Section 31 add? What it provides is an answer to the question as to whether or not it is appropriate to give effect to an issue estoppel in circumstances where the party impleaded is a sovereign state. It isn't actually, your Lordship, in a sense, if your Lordship's question is do we need it, the answer is, strictly speaking, no. But it does provide the answer to any concern that a court might otherwise have. About does it perhaps go to Mr. Flynn's point about competing underlying policies? That it shows that the United Kingdom, or England and Wales, I'm not sure how far it is, the United Kingdom.
I think it is UK, yes.
The United Kingdom is not implacably opposed to foreign judgments being enforced and relied on here.
Absolutely. It certainly does that, and when we get to that stage of the argument, and the competing public policy arguments, we have a number of answers before we get to that point. But what Benyon tells you is that a common law principle can't be relied upon if it is repugnant to a statutory regime. And my learned friend would wish you to accept that giving effect to an issue estoppel is repugnant to the State Immunity Act. If it is in fact required, if recognition of the foreign judgment is in fact required under the Civil Jurisdiction and Judgments Act, then it can't possibly be suggested that giving effect to the issue estoppel would be repugnant to the statutory regime.
Yeah.
So, as a matter of, given that that is the framework for the debate, when one actually analyses what my learned friend's submissions are, the first point is that both in writing and orally, my learned friend's submissions principally consist of a repeated assertion that state immunity is important. And that the court here has to give effect to state immunity in the sense that it's not a discretionary matter. If state immunity exists, it has to be given effect. Well, there's no dispute about that, but that doesn't begin to answer the question that is before you, which is how does the court set about deciding whether state immunity arises or whether one of the exceptions applies? Simply repeating that state immunity is very important and it's a matter of international significance does not begin to answer the question as to how the court sets about answering whether state immunity applies in any given case. Of course, if it exists, the court must give effect to it. You've got to reach the decision as to whether it exists in the circumstances of any given case. The issues, it may be useful because there's been a certain amount of elision and there may have been a certain amount of abandonment of the arguments that were set out in the grounds of appeal and in the original skeleton. Can we just make sure that we all understand what is in play and what isn't? And I just wanted to go to the amended grounds of appeal, which are in the core bundle at tab 13. And my learned friend took the first three grounds together, but they are making different points. Ground one, issue estoppel is not applicable in respect of a foreign judgment against a state, not least on an issue of state immunity. So the point that was being advanced in ground one is not in fact limited to state immunity, but it is an assertion that a foreign judgment can never give rise to a state to an issue estoppel. Ground two, over the page, there is no scope for issue estoppel to apply when determining whether state immunity is available under the State Immunity Act. My learned friend appears to have rowed back from that by accepting that issue estoppel can arise on the basis of an a prior English judgment. Exactly how that works as a matter of analysis, we'll have to try and unpick. And then Section 31 is dealt with exactly what was intended to be conveyed by the words, the Section 31 is not available as an overlay for a common law issue estoppel determination, is somewhat opaque. But my learned friend's argument is in fact that Section 31 is somehow not applicable at all in the circumstances of this case. But I will deal with Section 31, special circumstances, and the ground 5, the special status of points of construction on a treaty separately towards the end. What I wanted to do first is just to grapple with the main points on which my learned friend has been addressing you today. Before doing that, we just wanted to emphasize that it would appear that there is a sort of whether it's a structural or a philosophical difference between my learned friend's argument and ours. My learned friend's argument appears to be advocating an absolutely inflexible rule that issue estoppel can never be invoked against a state on the basis of the oral argument in relation to state immunity based on a foreign judgment. Our argument is more fact-sensitive. We recognise that it will not always be appropriate to give effect to an issue estoppel against a state which is claiming state immunity, and looping back to the Section 31 point, if, for example, if a party here sought to rely on a foreign judgment which does not satisfy the requirements of Section 31, then the court here may well be entitled not to give effect to an issue estoppel based on that judgment. So the battle lines between the parties are that my learned friend, as I say, is advocating an inflexible rule that the court can never resort to issue estoppel. We submit that the court is entitled to rely on an issue estoppel, or entitled to give effect to an issue estoppel, but is not always going to be bound to do so.
Because it would be odd to have an issue estoppel if it was a judgment that wouldn't be recognised under Section 31.
Exactly so. So we just, again, because the way the argument has been presented orally departs somewhat from the way it was, certainly from the way it was first put, and to some extent from the way it has been put in the supplemental skeleton. Can we just turn to the supplemental skeleton to identify the 3 points that are presented there? So it's in tab 12 of the core bundle, and it's the first 3 subparagraphs of paragraph 1, so page 158 of the bundle. 1.1, the central question in this appeal is the scope of the English court's obligation under Section 1.2. That question goes to the heart of grounds 1 to 3. The short answer is to start with the statute. The court has recently confirmed that this provision requires that the English court must determine on a final and not merely interlocutory basis whether the ground for immunity exists, and that this determination must establish to the civil standard whether an exemption to that immunity. And then the critical point in this subparagraph, the Russian Federation's central submission in this appeal is that it must follow that by Section 1, an English court is under an obligation to consider all arguments for and against state immunity, weigh up the evidence underpinning them, and determine issues for itself. In other words, the English court must determine the question of state immunity de novo without deference to any purported issue estoppel. So that's the absolutist approach. And then subparagraph 2, and these are very closely related, but I will identify them and deal with them separately. Subparagraph 2 is this assertion that if you give effect to an issue estoppel, you're not actually taking a decision at all. And having been taken to Mills and Cooper, you will see that the only basis upon which that assertion can be made is in fact by not quoting the full passage. Because as my Lord Justice Lewison pointed out, what Mills and Cooper says is that Lord Justice Ditlock there said that the application of an issue estoppel results in there being no issue to which the evidence would be relevant. My learned friend has cut off the quotation by saying results in there being no issue for determination at all. That is not, in fact, what the judgment says. The third point, so the second point is there isn't a determination at all, and the third point is that it is essentially the sort of the balance, the competing, supposedly competing public interests. On the one hand, supporting issue estoppel, and on the other, supporting state immunity. And my learned friend suggests that there's a sort of competition between the two, and that state immunity wins that competition. So those, as we understand it, are the three planks of the Russian Federation's first argument. And if I could deal with them in turn. So the first one is the point of absolute principle, that the State Immunity Act itself demands that the English court must always make its own mind up in relation to state immunity de novo, and never give effect to an issue estoppel. It's not entirely clear why my learned friend concedes that an issue estoppel would arise based on an English judgment. I don't know if that's a form of a vote of confidence in the English judiciary on the basis that you must always be right, or whether there is some principled point underlying it. But if the point is that the foreign state is always entitled to run its case on state immunity, it is impossible to see why a distinction should be drawn between giving issue estoppel effect to an English judgment and issue estoppel effect to a foreign judgment. And indeed, in a sense, the converse argument is exactly what Carl Zeiss dealt with, because Carl Zeiss dealt with the question of whether should you give issue estoppel effect to a foreign judgment. And ultimately, the answer was, well, if you give issue estoppel effect to an English judgment, we can't see why you shouldn't give issue estoppel effect to a foreign judgment. And we would submit that my learned friend's concession, I mean, it's a pragmatic concession on his feet, but it is unprincipled, and it undermines the coherence of the argument that he is seeking to advance.
But I think Mr. Flynn's point was that this court will then have complied with its obligation under Section 1, or albeit in some other proceeding.
Well, that again is simply an assertion. With respect, it is incoherent. In a sense, I would bounce back to my Lord Justice Mayall's question, which is, why isn't this court satisfying its obligations under the State Immunity Act and customary international law by giving issue estoppel effect to a foreign judgment? Is that because the foreign judgments are regarded as being potentially fallible, whereas English ones are not? And if an English judgment has been given, it is no more infallible than a foreign judgment.
Well, I think his point would probably be that the obligation is cast as a matter of international law on the United Kingdom. And the United Kingdom gives effect to its obligation under international law by one of its courts. making the decision.
Yes.
Whereas if the English court relies on a foreign judgment, it is the United Kingdom, qua international actor, is not making its own decision.
Yeah.
I think that's the way he would reconcile it.
Okay. Well, Lord, I'm grateful for your lordship's clear articulation of my learned friend's argument. But I'll get to the constituent elements of it in a moment. But we just wanted to point out that concession and that apparent inconsistency. But returning to the main point,
I think there's one other point to be made just at this stage. Mr. Flynn accepted that the foreign state had to comply with procedural rules, and that a decision on the question of state immunity could be taken in the absence of evidence if the foreign state had failed to comply with whatever timetable that was appropriate for the presentation of it.
yes.
So when he says that the English court must weigh up the evidence, that may or may not be so, depending on what's happened procedurally.
Yes. Well, I was going to get to that, because that's essentially what happened in the Zhongshan case. And to an extent, it also happened in Bencar-Bush, where Libya was shut out from presenting its appeal because it hadn't paid security for costs. So plainly, there are procedural mechanisms by which a foreign state is disabled from advancing the arguments that it would wish under state immunity. And I will simply make the point now rather than later, but that again undermines the integrity of my learned friend's argument, because it demonstrates that the English court doesn't always have to decide de novo on the merits, on the evidence, every point that a foreign state wants to run. Foreign states can be precluded by procedural non-compliance with directions for filing evidence from arguing their points. So if there is that much of an inroad, which can be a complete inroad, so to speak, into the foreign state's ability to run its arguments on the evidence, if there can be that degree of inroad which my learned friend concedes, what principal distinction is there between that and a situation where the English court decides on state immunity, but it does so by reference to a limited body of evidence, namely a foreign judgment? Essentially, sorry, I'm now going to go back to where I said I was going to go, which is addressing the main point, this argument of principle that Section 1 of the State Immunity Act requires the English court to decide de novo on the evidence the argument on state immunity. Essentially, the argument in our submission is simply based on a non sequitur. What Russia is saying is state immunity is very, very important, and therefore the English court has to make up its own mind on all the underlying, from the primary evidential material, de novo, without regards to a foreign judgment. And one sees the gap in the logic. If we turn again to my learned friend's supplemental skeleton, I don't know if you've still got it open, at page 159, and he picks up the thread at paragraph 2. That conclusion is unremarkable when one considers the purpose and exceptionalism of state immunity. It is a doctrine governing the UK's relationship with other states on the international plane and under international law, and the English court is entrusted by Parliament to apply it. Its non- or misapplication by the English courts could very well affect the UK's relationship with foreign states and could engage the responsibility of the UK to the foreign state for breach of customary international law. A de novo review of the grounds upon which it applies or does not apply must therefore be the minimum exercise that the English court is obliged to undertake. There is, with the greatest respect, simply no logical connection between those two assertions. State immunity is very important, but that cannot logically lead to the asserted conclusion that therefore the English court must always make its own decision de novo on the evidence. Again, I think it was possibly at this point that my Lord Justice Mayles put the question, well, why do you say that? Is it on the basis that somehow foreign judgments are potentially fallible, whereas English ones aren't? And there isn't, with the greatest respect, a coherent answer to the question as to why the therefore appears in that sentence. So in a sense, that's our sort of top line answer to this whole line of argument. I'm obviously not going to leave it there, but we do urge on you that the whole edifice of this argument is based on the non sequitur. But to develop the argument in a little more detail, first of all, just by reference to principle, we can all agree that state immunity is important, and that if, under Section 1, a state is entitled to immunity, then the court is required to give effect to that immunity, even if the state doesn't appear. It's not a discretion, it's an obligation if the immunity exists. But, self-evidently, the court is only required to give effect to immunity if it does exist. And the immunity does not exist if, among other things, the exception under Section 9 applies. So, the question in this case, as in any other case, where enforcement proceedings are brought against a foreign state on the basis of an arbitral award, the English court simply has to decide whether Section 9 applies in order to determine whether the state is entitled to immunity under Section 1. But, as Mrs. Justice Cockerill observed, the Act says nothing about how the court should set about determining that issue. My learned friend kept saying that his argument was based on Section 1, but there is nothing in Section 1 that tells you how the court reaches its decisions as to whether or not one of the exceptions applies. What the State Immunity Act does not do is it does not disapply any procedural or substantive rules of English law for the determination of any disputed issue. And as a result, when the court is deciding whether state immunity applies or an exception applies, the court applies the general law. And the general law includes issue estoppel. That is our answer of principle. We cited some case law in the court below, and a millennial friend has referred to it and says, well, that's not decisive because it doesn't actually squarely address issue estoppel against the state in relation to a claim to state immunity. We entirely accept that, and the judge rightly recognised that. But what the authorities do show, the authorities that we cited and which Her Ladyship quotes, what they do show is that issue estoppel plainly does have a role to play in relation to the enforcement of arbitration awards against a state. And the two cases you will recall are Dalla and Pakistan and Diacumen and the Czech Republic. If we just look at, you will have seen it, but just to remind you, it's in the judgment below, so 4 bundle tab 3, page 24. I'm not absolutely sure why, but Dalla didn't actually get into the authorities bundle, but the relevant passages are quoted here. What has actually happened in that case, in a sense, was the sort of the reverse of this case, because what had happened was that the respondents to the arbitration proceedings, Pakistan, had not challenged the awards in the curial courts. And the argument then in this jurisdiction was, well, if you haven't challenged them in the curial courts, are you now sort of Henderson and Henderson barred from challenging them here? So plainly, it wasn't addressing directly the point. But as Her Ladyship says, if you've got page 24 open, as Her Ladyship said at paragraph 31, there are two cases which implicitly recognise the possibility of issue estoppel against a state. And as Lord Justice Ricks is quoted there, and we would seek to get nothing more if we had the full report, it's just that these few lines, as for the case of a successful or unsuccessful or waived challenge in the courts of the country of origin, that's a more controversial area. My own view is that a successful challenge is not only in itself a potential defence under the Convention or our statute, but likely also to raise an issue estoppel. As for an unsuccessful challenge, which is what we have in this case, that may also set up an issue estoppel. So
the Convention is the New York Convention, presumably.
Yes.
What is our statute? Is that the State Immunity Act or the Arbitration Act?
I will have to go back and look at the case to answer that. Yeah, I'll have to go back and check. I'm sorry. But then Lord Collins over the page, paragraph 34, quoting paragraph 98 of Lord Collins, where he says, in an international commercial arbitration, a party which objects to the jurisdiction of the tribunal has two options. It can challenge the tribunal's jurisdiction in the courts of the arbitral seat, and it can resist enforcement in the court before which the award is brought for recognition and enforcement. These two options are not mutually exclusive, although in some cases a determination by the court of the seat may give rise to an issue estoppel or other preclusive effect in the court in which enforcement is sought. And that was being said by His Lordship, albeit obiter, but in the context of an hypothetical unsuccessful challenge in the curial courts, which is in relation to an arbitration award against a state. And that's exactly the situation here.
So the argument, is this right, from Mr. Flynn, is that you can have an issue estoppel on the very question of whether there is a binding arbitration agreement, provided that that does not arise in the context of state immunity, but you cannot have an issue estoppel on that same question if it does arise in deciding a state immunity point.
Well, that may well be his argument. Yes, I think Your Lordship is right that that was the concession and the assertion that was made. I don't want to anticipate, because I don't want to get ahead of myself, but we will have some detailed submissions about what the court is and isn't deciding under Section 9 and then under Section 1 when it is presented with a Dutch judgment which says Russia agrees to arbitrate. Because one needs to unpick exactly how far the issue estoppel goes, so to speak, in determining definitively the state immunity question. But I do want to come back to that. I was going to turn to diacumen and the Czech Republic, which we do have in the authorities bundle, but I'm conscious of the time, but that'd be a convenient moment.
Sure. 2 o'clock. Just before we rise, are we going to finish this today?
Well, depending on how expansive my learned friend's reply is, I think there is every prospect. I don't know what time you would be inclined to stop at.
Well, it depends on where we've got to, I think.
Well, I'll try and, to be honest, I hadn't anticipated being on my feet before lunch at all, bearing in mind the overall time estimate. So we're ahead of the game, and I'm making good progress. So I would anticipate there's every possibility that I'll be sitting down by 3:30.
Right. All right. Good. 2 o'clock.